I was just talking with somebody out in the hall earlier about capacity. I assume that you all have issues from time to time with people, clients, that there's some question about whether or not they have capacity to make decisions. Is that fairly common? Is that easy? No. Okay. So we're going to spend some time on talking about capacity. The first place I got to start is legal definitions of capacity, recognizing capacity. The one thing about recognizing capacity, I figured out that you're all capable. You know how I figured that out? You're here. Presumption is you drove yourself here. And so for the vast majority of people, it's relatively easy to know if they have capacity. In fact, what does the law presume? Law presumes you're capable, that you have capacity to do whatever it is that you're attempting to do. And yet, it's a really big problem. Right? Making sure that the person we're dealing with does, in fact, have capacity. I thought I had another slide to say. So the issue with capacity, and I've got something here I actually want to read, because, you know, there's statutes that deal with what capacity is. Like what the statute says, to execute a will in Connecticut, any person 18 years of age or older and of sound mind may dispose of his estate by will. The capacity to create a will, the legal standard, is about as low as you can get when it comes to being able to execute a will. Most people don't understand that. Is that if you know the objects of your natural bounty, that's old English stuff, okay? And you know you have some bounty, meaning your stuff, your assets, right? Then that's enough to be able to enter into a will, to create your will. That is about the lowest threshold out there. I'm not aware of any lower. But for a conservatorship, the threshold we have to determine is, are you capable of caring for yourself, or incapable of caring for himself or herself? It means that you have a mental, emotional, or physical condition that results in such person being unable to receive and evaluate information or make or communicate decisions to such an extent that the person is unable, even with appropriate assistance, to meet essential requirements for personal needs. Incapable of managing his or her affairs means that the person has a mental or emotional or physical condition that results in such person being unable to receive and evaluate information or make or communicate decisions to such an extent the person is unable, even with appropriate assistance, to perform the functions inherent in managing his or her affairs, and the person has property that will be wasted or dissipated unless adequate property management is provided. And it goes on some. That's right out of the statute. Did that help you figure out if somebody's capable? No. Because what does appropriate assistance mean? See, because built into that language is a presumption you've got limitations that all by yourself you can't, but if somehow we get you the right help, you can. Now, one of the things that I have seen a lot is somebody clearly has some cognitive failing. First off, let me ask another question. If somebody has been diagnosed with Alzheimer's, are they no longer capable of managing their affairs? How many think they're no longer capable? Good. You're better than a lot of white audiences. Okay? So just because you have a diagnosis of dementia doesn't mean you can't manage your affairs. But at what point does the dementia become so invasive in terms of affecting your ability to function? Can you no longer do it? That is a really wide, fuzzy line. And is it something that once you're not competent, you're no longer ever competent? No. I mean, we have folks that they have good days and bad days. Sometimes they have bad weeks and good days. So we have to be sure that we have done everything we can to evaluate that individual, to be sure that they are capable of entering into agreements, whether we're talking about trusts or contracts. Are they really able to understand what they're doing? That's the critical thing. Now, are attorneys the best ones equipped to do that?
Probably not.
No. Are social workers? I heard a yes. All right. Okay. So part of it is clearly based on experience. Part of it is understanding personality styles, and somebody may just not be very communicative, but they do in fact understand, and they can convey what they want and what's important to them. So it is part of the job of the attorney to do what they can to be sure that the person they're dealing with understands what they're looking at doing, what, to the extent that it's relevant, what the consequences are of what they're going to do, because this is really important. Now, and I'm going to pick on you as a group, which is not fair. The thing I see lots of social workers do is at literally the first sign that somebody is genuinely having a problem managing their affairs, taking care of the person, they automatically say this person needs a conservator. Now, here's what I'm going to tell you about getting a conservator. I believe that it's one of the last things, and it should be the very last thing that you do. Okay? And the law is structured so that it says it should be, but I find all too often it's one of the first defaults. And we're going to talk about conservatorships here in just a few minutes, but I'm going to go back and talk a little bit about powers of attorney. We've had significant changes to the power of attorney statutes. It took about 3 years to pass the first change. The first change in about 50 years was passed in 2015. It took about 40 pages to try and fix known problems with the Connecticut short form power of attorney. And then in 2016, they passed some more changes. And I haven't updated this slide since early 2017. At the end of the legislative session last year, they made some more changes, all of which were to try and get that power of attorney. Oh, by the way, how many powers of attorney are there? Is there a power of attorney? There's 2. I got somebody brave enough to vote. Thank you. Yeah?
1, 2.
Okay. 2. 1, 2. 1, 2. Now, here's the thing. There are statutory powers of attorney forms. When the legislation was passed in 2015, before and right after, there was one statutory short form power of attorney. What came out of the 2016 legislation in 2017 is we now have a statutory short form power of attorney, and we have a statutory short form power of attorney with optional provisions. how do you know if you want the optional provisions? Okay? So while the legislature is trying to solve problems, what the law really says is so long as you follow the appropriate execution formalities, there are formalities now that there didn't used to be, that you literally can have, there's space up here, Jay, if you want a table. Which one? Okay. So the important thing is that you have a instrument that when presented to a third party, it's going to be accepted. Okay? Oh, y'all know what a camel is? No, don't. Camel is a horse created by the legislature. Well, you're going to be a tough audience. I'm going to be tired. Whoa. I'll walk closer to that horse. Okay? Here's the thing. What we see most people having is a statutory document, a form created by the legislature. And there are a lot of known problems with this document. And one of the big problems that this legislation that was passed in 15, 16, and 17 was trying to solve was to try and create a document that third parties would accept. That was one of the big known problems, is banks routinely didn't want to accept it. I see some folks nodding heads, you've had some experience with that. Okay? So here's the solution, or the solution that the legislature came up with to make it acceptable. Is if the bank, if that institution doesn't have a good faith reason for not accepting the power of attorney, then your agent under the power of attorney, the power of attorney is a document, creates an agent, gives them authority. When that agent goes to the bank and says, hey, I want to close Meg's bank account. There's a problem sitting in front of it, okay? And the bank says, well, no, I won't accept it. The most common reason they objected to it was because it was too old. Okay? But under the new law, if they don't want to accept it because it's too old, well, that maybe isn't a good faith reason for not accepting it. If the agent says, hey, bank, you really have to accept this, they still refuse, then the law says, well, you agent, you can sue the bank to compel them to accept your direction under the power of attorney. What's the problem with that?
It costs you money.
Oh, but the legislature's thought about the fix to that. If you win, you get your reasonable attorney's fees. Is this a good fix? No. They did do some other things to try and help out. One, powers of attorney now have the signature of the principal. They have to be witnessed. And if that signature is witnessed, then that is presumptively means that it's a valid signature and it was validly created. Okay? So that takes away one of their arguments. And there is a provision in the statute now, something we have been doing informally without statutory authority for a number of years, that if you can get an opinion from the attorney that says it should be accepted, well, that's, maybe that helps us get the third party to accept it. Okay? But again, do you know whether you need those optional provisions or not? Okay? All powers of attorney are now presumed durable. So under the prior law, if the granting of the creation didn't say that it was durable, meaning that it would work when you were incapable, it didn't work. So there was a lot that failed because of that, because they didn't say it. Now they're presumed to be durable, meaning they're good. They're good when you sign them, and they continue to be good during any incapacity that you have right up until you die. Because a power of attorney is no longer a useful document once you die, because when you die, any authority that you have dies with you, therefore your agent has no authority. Okay? If we want our agent under a power of attorney to be able to take our property and transfer it to somebody else without receiving equal value, that's a definition of a gift. I transfer something and I don't get as much back as I gave. It's a gift. The power of attorney has to have specific language in it about the gifting. And this is one of the reasons why many powers of attorney completely fail. Because we've got somebody who's incapacitated, they're older, we want to do some planning to help them qualify to get help, whether it's veterans benefits or Medicaid or whatever, if we need to move those assets around. And that movement would constitute a gift. Without specific authority, it can't be done. We also have a problem with self-dealing. Most of you deal with clients and powers of attorney. I kind of need to know where we are here as a group. Okay? Some of you do. Okay? So, in most cases, the client is going to name somebody close to them. It's going to be a spouse. It's going to be an adult child. Might be a sibling. But one of the problems is the law does not allow an agent to do transfers to themselves. They can be set aside. They can be voided. Okay? Now, so if you named your best child, gave them the authority to do this stuff, and they can rearrange stuff amongst everybody in the family, but not to you, and you're the one doing the work, that's a problem. So you have to be sure that the document actually allows you to do all the things that you want to do. And it's really tough to look at that 2-page or maybe 3-page document. Most of them don't make it clear what the level of authority is. So you have to read it carefully, and you may want to consult with an attorney about it. So you can specify, you can have a power of attorney that only lets somebody deal with just real estate. Or you can, more generally, we're going to try and have as broad a set of authority as we can grant, but have enough instructions so that whoever we've named is going to inadvertently ruin the planning that we've already started or have already completed. You can always revoke a power of attorney, assuming you're still capable. If you're not capable, you don't have the ability to revoke what you created. There is a lot of concern by banks and others about liability. And so what big part of what that law did is say if you're relied on this power of attorney, if your reliance was reasonable, then that third party can't be compelled to cough up more money. Because what the banks are worried about, your agent or power of attorney comes in and takes all the money out of the account, and then the principal, the person who created that power of attorney, comes along and says, well, they weren't supposed to do that, okay? Give me my money. And that's why the banks and other financial institutions are concerned about these powers of attorney. And so they've got provisions as to the liability. They made them immune. The statute makes it clear that your agent and a principal under a power of attorney is entitled to get paid. It's best to spell that out in the document as opposed to relying upon the statute. And how do you want them to get paid? Okay? We already talked about the 2 statutory forms. Out-of-state POAs, the statute says if the power of attorney that you have from Mississippi or Alaska or Massachusetts, if it would be valid there, it should be valid here. But from a practical standpoint, if you have folks coming in from those other states that are becoming residents of Connecticut, they should update those documents so that because most of their business is going to be here in Connecticut. If they're living here, it will be easier to get a Connecticut power of attorney accepted than one from out of state. Conservatorship. We started talking about conservatorships a little bit earlier. Any of you have experience with conservatorships? A lot of you, okay? So, there are two kinds of conservatorships, voluntary and involuntary. Voluntary is when you decide, I'm just tired of taking care of all this stuff, I want somebody else to do it for me. You file a petition with the probate court, tell them it's voluntary. You're going to have a hearing with the judge is going to ask you, are you really sure you want to do this? And in my experience, so far, 100% of the time, voluntary conservatorships get granted, and the court names who you want to do it. The bigger one, and where I think far and away the majority of the conservatorships come about, is they'll be involuntary. Okay? And an involuntary conservatorship is you didn't do the things the law says you can do to not have one. Did you all hear that? How many conservatorships should we have? Almost none. It's really easy to get a power of attorney and a healthcare power and a living will. It's really easy. If you do that, and if you get your clients to do that, they probably will never have to worry about a conservatorship at all. So, I put up here, the other thing is there's something that Connecticut does that most other states don't do, is they say, you can tell the court who you want to be your conservator while you're still well. And so, in other words, if you can accept, or if your clients can accept, that it is possible at some point in time, for some reason, you may not be able to manage your own affairs, whether it's financial or your person, then we can do something called an advanced designation of conservator, where we tell the probate court who you want named. And it can be different people, and in fact, when they changed this back in 2000, I think it was 5, might have been 7, when they changed this, we spent a little time looking at it, and now we do two things when it comes to advanced designation of conservator. We do the basic, which the law says is, hey, here's who I want, judge, if you decide I need a conservator. But we did something else, because the law says that an order of conservatorship is to be the least restrictive thing that the court can do to make sure that you get taken care of. So where we've done the planning, we also tell the court, and oh, by the way, I named the power of attorney, and here's who they are. And I named the healthcare power of attorney, and here's who they're. And if we've done trust, we tell them that I've got trust. We lay it out and say, basically, we say, Judge, we don't know why I'm here yet, okay? But we believe that we've done everything the law lets us do, so, go away. We don't need you. Because once a conservator is appointed, the conservatorship continues until you prove to the court you're competent. How many of you want to go prove your competence? Yeah. So here's the process for an involuntary conservatorship. We have to file a petition. Well, when we file the petition, it says, Jay is incompetent and somebody needs to look after him. Okay? We have to get a doctor's opinion that says that he's not competent, and that needs to be typically within 30 days of the hearing that has to be done. The court is going to notice, I thought I had it down, the court is going to notice all of the people that are interested in Jay's life. He's got a spouse, the spouse gets noticed, adult children, all the statute says who those are going to be for everybody, and they're invited to come in and express their opinion about who should be conservator and where the court should go. Oh, by the way, if you're the alleged incapacitated, you do have to participate in this. And so there are a lot of these hearings that are held in nursing homes and hospitals and whatever, because the court literally goes to you if you can't get there. Okay? The exception to that is if it's an emergency appointment. You can typically get an emergency appointment done in 24 to 48 hours. Hard to do that on a weekend. Okay? You don't get it done on a weekend. But then you've got to get it made permanent within 30 days. Oh, and one of the big changes in the law is once we file this petition, one of the first things the court does is they're going to appoint an attorney to look after the interest of the alleged incompetent. Who gets to pay for all this? If the client has funds, they're going to have to pay for it. If their income is low enough and they have essentially no assets, then the court's going to use court-appointed people to do the whole thing. So, we use trusts a lot as a means to manage people's affairs when they're incapacitated. Because what's the problem with powers of attorney? Oh, by the way, as I go along here, I'm going to test to see if I'm keeping you awake and are you learning anything. Okay? So please talk back to me. Okay? When's the last time you've been invited to talk back? Okay? So, what's one of the problems with the power of attorney? Financial power of attorney. What's one of the problems?
It ends when you die.
I'm sorry. It ends when you die. That's a good one. What else?
It can be revoked.
Well, it can be revoked, which is, I think, a benefit maybe, but why does the fact it could be revoked, why does that present an issue?
Because then you can cash it in to pay for nursing homes.
Okay. Here's the problem. We need authority for somebody to act on our behalf that we know is going to work when we need them to do it. And if I go into the bank with Megan's power of attorney and they don't want to accept it, does that work?
No.
Forget all the safeguards and all the stuff the legislature tried to do to make it acceptable. The fundamental problem is all too often we're going to have a challenge. Now, my friend Jay is sitting up here in the front. I told him I was doing this and he said he wanted to correct. Jay is a very successful financial planner. Also does a tremendous amount of work with folks with Medicare and supplements. Have you ever had a problem getting a power of attorney accepted? Happens all the time, right? Now, and so what we think people should be doing, instead of focusing on getting documents, they need to think about how they're going to get the results they want. And so one of the reasons we use trusts, and these are typically revocable trusts, we use irrevocable trusts, which we'll talk about later today, is because if we have a successor trustee and we have the assets that we're trying to make sure we can manage, if we have them owned by the trust, okay, then third parties have to deal with the true owner of the asset, which is going to be whoever the trustee is. We have largely solved the I don't want to accept the power of attorney. It doesn't mean we don't do powers of attorney, because not everything can be controlled with a trust. But, so we've got a trustee, and we always name a successor. We even have methods of choosing a successor for some reason a successor is not available. And you know how long it takes us to get authority from one trustee to another? How long do you think it, because that conservatorship process, that can take months. It always takes weeks anymore when it's involuntary. How long do you think it takes to get authority from you as trustee to your successor trustee? How long do you think? Any guesses? You're not a very brave group. Okay? We can actually, in a matter of, from the phone call to meeting with somebody, we can typically have it all done in a couple hours. Okay? So it is much more efficient. And it is far less likely to have any problems with it in terms of being able to manage the things we're trying to manage.